Welcome to this presentation, which looks at the experience of local government reorganisation through the lens of an internal legal department that led on all the governance changes in North Yorkshire. My name is Barry Khan and I'm the Assistant Chief Exec for Legal and Democratic Services for North Yorkshire Council and a Director on the Council's wholly owned legal firm First North Law. I was also the Monitoring Officer of the County Council prior to reorganisation. You will also hear from Jennifer Norton, who was one of the monitoring officers of one of the borough councils prior to reorganisation. We want to provide a presentation that we hope people going through this process will find useful and told firsthand by internal council staff that went through this process. So this is the story of how two tiers of local government in North Yorkshire became one.
My name is Jennifer Norton and I'm the Assistant Director for Legal and Deputy Monitoring Officer at North Yorkshire Council. Prior to Local Government Reorganisation, I was the Monitoring Officer of Harrogate Borough Council, and as such I've been involved throughout the Local Government Reorganisation process, advising on various aspects of reorganisation, and was part of the team that helped ensure the new unitary could operate safely and legally from vesting day.
This slide shows the 8 councils within North Yorkshire that existed prior to reorganisation. There were 7 district and borough councils and 1 county council. This presentation will go through, at a high level, the process that was followed to create one unitary council. This slide shows the various stages of the process from the initial bid to the creation of the new authority. We discuss the process in 6 stages, which starts with the bid, then the decision by the Secretary of State, then the passing of the Structural Changes Order, then we look at the election of members to the new authority, then the potential to put spending restrictions on predecessor councils, and then finally the vesting day for the new authority. We'll also touch on the creation of town councils and community governance reviews that we undertook to fulfil promises that were made as part of the reorganisation. As you will be aware, the process of submitting bids to government on what the councils should look like after reorganisation can be a time for political tension, as competing bids can be submitted. Within our area in North Yorkshire, there were 2 alternative bids, and each bid used a different governance model for the basis of the creation of the new council or councils. Whilst it is important for colleagues and the public to understand that under either model there is a new council or councils that are being created, from a legal perspective there are basically 2 types of governance models. Firstly, the new legal entity model. This looks at legally creating a brand new legal entity or entities that will be formed to form the basis of the councils. Prior to the creation of these new councils, there will be a shadow authority and a shadow executive created that will be able to make decisions on behalf of the new organisation prior to all staff and assets being transferred to the new authority. The second type of model is what government call a continuing authority model. The terminology is not found in legislation, but is what is referred to when an existing council is used as the basis of the creation of the new council. This has what is known as the preparing council and an implementation executive to make the necessary decisions on behalf of the new unitary council before it is created. In North Yorkshire, there are 2 alternative bids, one for a east-west split and one for a North Yorkshire sole unitary council for the geography of the previous county council. Government was therefore asked to make a decision on the 2 competing bids for North Yorkshire, and the Secretary of State carried out the necessary consultation and considered both bids. On the 21st of July 2021, the decision was made to approve the bid to create North Yorkshire Council on a continuing authority basis. Once the government had made its decision, the councils then needed to organise ourselves to create a governance structure for decisions to be made prior to vesting date. From a legal side, the civil servants from government will then start drafting the structural change order which will implement the changes. We found working with central government civil servants to be a real positive experience, and they were willing to listen to our views and help ensure that the structural change order reflected any local issues. They were clear that the actual drafting of the order is for them, but they were very willing to listen to what was needed to be included. I would say having a good working relationship with the civil servants that are assigned to your reorganisation is really helpful and will put you in good stead for the future. After the decision was made, it was important that we had strong programme management for all councils to work together to create the new council. We split the work out into a number of work streams for officers as shown on this slide to ensure there was a safe and legal new authority from day one. I was the project sponsor for the governance work stream and was assisted by a very talented team that looked at all the legal and governance issues involved in creating the new North Yorkshire Council. Every work stream sponsor will have seen the process of reorganisation through a different lens, and this presentation looks specifically at the governance and legal elements of the transfer to the new organisation. So, looking at the decision-making structures, we tried to ensure that we had a consistent approach of engaging with members and officers from all councils from after the decision was made until the new organisation was created. We knew that there would be three main stages of decision-making prior to the creation of the new authority. Firstly, a time after the decision was made, but before the making of the structural change order. There is not a prescribed set of rules on how to formulate your decision making, so we mirrored the decision making that was going to be in place after the order was made. This was the second stage in the process. The third stage in the process was after the councillors were elected to run the new council, but before the council was created. This complicated slide shows how those three stages of decision making was formed, which I'll talk about in more detail, but I've shown them in one slide to show the similarities of the process that we adopted, which served us well in the creation of the new council. So going through the first stage of that process for when the decision was made, but before the order was passed, we wanted to create a structure that would engage with all 8 councils through informal arrangements that would mirror the formal structure that was to come. This would allow work to commence to create the new authority and enable a smooth transition to when the formal arrangements were put in place. There is a lot of work that needs to be done, and the sooner this can start, the better. Also, it was helpful in building up a one-team approach to create the new authority and to provide a platform for members and officers to come together to implement the government's decision. When you have had officers and members working on competing bids, this is a good time to come together and collaborate on the considerable amount of work that is needed to create the new council or councils. Starting at the top of this slide, we show that the predecessor councils are still sovereign, but we created an informal joint committee of members from all councils, including their leaders, to work together to oversee the transitional work on a political level. Underneath that level, we created an informal implementation board of chief executives from all councils and other senior officers to sponsor the various work streams that were needed. And underneath that, we had an implementation plan, which was project managed to ensure that we had a coordinated approach in working on the work streams. When the government passed the structural change order, then it formally created in law the implementation arrangements for the new council. The order itself creates an implementation executive or a shadow executive depending on your governance model, which is a committee of members from all the councils, and it also creates an implementation team of officers. Both of these bodies have a legal duty to create an implementation plan, which is the document which describes how we will ensure a smooth transition from the predecessor councils to the new council. At this stage, the interim head of paid service, the interim chief finance officer, and the interim monitoring officer were appointed. We made those appointments internally. In addition, at this stage, formal TUPE consultation can take place. From our experience, what worked really well is that we used internal resource as much as possible to ensure that there was real ownership of the outcomes for the new authority, and only supplemented that core work with external consultants where it was sensible and necessary to do so. From my perspective, it was important that internal, legal, democratic and election staff are engaged from all of the councils to ensure that the new arrangements work well and are widely understood. This slide shows how those arrangements worked, with the informal joint committee of members being formally replaced with the formal implementation executive. The level below that shows the implementation team of officers, where officers continued to work on the implementation plan, but now this had legal force through the structural change order, and there is a legal duty for all the councils to cooperate in preparing the implementation plan. As this particular phase for us only lasted just over 2 months, it was helpful that we had already mirrored this arrangement previously so that the work could continue to be done. So for us in North Yorkshire, soon after the passing of the order, we held elections for the new authority. This was a vital stage of the process to ensure that we had the elected officials in place who would ultimately oversee the new council so they could make the necessary decisions to enable a smooth transition from the 8 councils into one. Our members and government recognised that the newly elected members had the democratic mandate and authority to make decisions going forward, even though we continued to have 8 councils in existence at this time. How did this work for us? Well, previously we had 72 councillors at the county council and over 200 councillors in our district and borough councils. After the election in May 2022, we increased the number of county councillors to 90, and their executive acted as the implementation executive for the new council. An interesting part of our original bid was that we had to state what would be the current number of councillors going forward for the new unitary council, and then we had to come up with boundaries for those new divisions or wards. This was a particularly intensive piece of work that involved lots of views from our members, but was an important building block for the new council. After the creation of the new council, the Boundary Commission then undertook a full boundary review in the first term of the council, and that's what they're currently in the process of. With regard to the newly elected members, we then worked closely with them to create the new constitution and the committee structure that they would like the new authority to have. This involved detailed working groups on what things like the licensing committee would look like, what planning committees and how they would be constituted, and what kind of scrutiny arrangements the new authority should be. And with those newly elected members, we were in a good place to work with them to make sure that they were happy with the new arrangements after vesting date. The decision-making structure after elections and before vesting date was that the executive of the newly elected councillors took over as the implementation executive, and we had new members in place who could make the decisions and have ownership of those decisions after vesting date. The implementation team of officers underneath remained the same, but had greater certainty that political decisions that were being made by the implementation executive could be implemented because those councillors would continue after vesting date. This was therefore a good time to get the constitution of the new council ready, so it was in place for day one, and that there would be appropriate schemes of delegation to committees and officers to make sure that we were safe and legal come vesting date. Next, let us look at potential restrictions on spending after the elections but prior to the creation of the new council. After the elections, the Secretary of State has the discretion to issue a direction which puts certain restrictions on all the councils prior to vesting date to ensure that sensible long-term financial decisions are made and that councils that are being ceased do not make decisions that are not in the best interests of the future of the new council. This process is known as the Section 24 notice, and it means that in our case, the implementation executive have the power to give approval for certain expenditure, certain revenue expenditure over £100,000 and certain capital expenditure over £1 million. In our case, such a direction was issued and there was really helpful work across all the Section 151 officers to ensure that there was an informal protocol in place prior to the issuing of the notice to ensure that expenditure of taxpayers' money was being appropriately scrutinised. After the passing of the direction, the implementation executive then granted a general consent for certain expenditure so that predecessor councils did not have to ask for permission for every bit of expenditure which breached these stated thresholds. Again, that was an area that worked really well in our reorganisation. And while there may be some demands for large expenditure to be made in certain areas before the expiry of the predecessor councils, it was really helpful to ensure that a longer term consideration was made for the new council and that there was these checks and balances in place. After vesting date, members of the new council will still want to ensure that expenditure is spent wisely in the locality, and therefore this restriction can act as a helpful safeguard to protect decisions that should be rightly made by the newly elected members with their democratic mandate to run the new council in the longer term. We then eventually got to vesting date, which for us was on the 1st of April 2022, and you can insert your own jokes about this being April Fool's Day here. However, for us, this was a monumental day as it created the new authority and we delivered on our ambition to be safe and legal on day one. And it has to be said, a considerable amount of work had been done by colleagues from a number of disciplines and was delivered by hugely talented and dedicated colleagues across all councils. With regards to legal, democratic and elections, this team worked really hard by this point and we had produced a helpful guide to staff about what the regulations provided with regard to the transfer of land, contracts and functions to the new authority. As well as the individual structural change order, there are a series of regulations that apply to all reorganisation, and these deal with how to look after the council's assets and liabilities. The actual details of these regulations are too large to go into in this overall presentation, but we found that by creating a team within legal to lead on each of these areas, we were able to produce a really useful governance survival guide for our colleagues and how all this worked. And the benefit of the internal team doing this meant that it assisted in creating a one team approach which is needed for this task. And I'm sure we'll be happy to share that guidance with you. For those councils that are still waiting for a decision, it's very helpful for councils to understand what contracts they have, what's the potential future procurement pipeline, what land they own, what litigation is currently in place, so that all of that information can be gathered to make sure that they're covered for the new organisation. Trying to collate information is a real key learning point with regards to what you need to have to ensure that you have a smooth transition to the new authority. And just when you thought all the hard work was done in creating the new authority, the regulations provide that there are a number of policies that the new authority must make as soon as practicable, but not later than 2 years from the creation of the authority. These policies are listed here and they relate to housing, licensing and council tax. Helpfully, there are some saving provisions in the general regulations, which means that many existing policies continue until the new council renews them. So you can have differing policies in different areas for the same council. However, these stated policies on this slide need to be improved within 2 years holistically for the new council. Then there are these policies in relation to the equalisation of council tax and the approval of a local plan, which have to be approved within 5 years from vesting date. And just to reiterate the point about the saving provisions, you do not have to have the same charging policies across the new council On day one, you can have different car parking charges, different charges for leisure services, for example, if that is what members want. The issue to bear in mind is about prioritisation and not having to do everything on day one.
One of the most common questions raised is, what does reorganisation mean for me as an employee of what will be a predecessor council, and what does it mean for my job? Relevant here are the staffing regulations, the full titles on the screen. Broadly speaking, they have the effect that employees of predecessor councils will enjoy the protection afforded by TUPE. So, you transfer on your current terms and conditions, and importantly, any dismissals by reason of redundancy ahead of vesting day in connection with the transfer are likely to be automatically unfair. There are specific provisions regarding the recruitment, appointment and dismissal of heads of paid service and other chief officers. Government may well say that councils need to take their own legal advice, both in terms of the interpretation of the legislation and how it applies in specific situations. That's something we would absolutely advocate, and it's also something which all authorities in North Yorkshire did ahead of reorganisation. There is an explanatory memorandum accompanying the regulations, and also the department issued some guidance on staffing issues in June 2008, which I understand government intend to reissue in due course. The guidance on staffing issues from 2008 does reference chief executives of predecessor councils for whom there's no alternative post on transfer being likely to be made redundant, and it also talks about there being nothing to prevent chief executives or other senior officers of predecessor councils from reaching agreements with their existing employers on terms of severance if they wish to leave before reorganisation. If you are thinking of going down that route of either a local staffing protocol or voluntary severance, then you will need to be mindful of a number of things in terms of who can authorise that, and in particular the statutory guidance on the making and disclosure of special severance payments by local authorities, especially if you're thinking of making payments in lieu of notice. And you'll need to think about your processes for disclosure that are required, and think about the role of your auditor in the process. Town and parish councils are independent institutions. They're separate legal entities. There is a common misconception that the new unitary will somehow be the parent authority that's responsible for resolving all parish and town council governance issues, or stepping in when they're not functioning as they should. Depending on the size of the new unitary, you may end up with lots of parish or town councils in your area. I think North Yorkshire holds the record on this, as we've got 729 parish areas with 412 town and parish councils. I'd therefore advise that you think carefully about what support and processes will need to be in place from vesting day to support the monitoring officer of the new unitary when it comes to considering standards complaints from town and parish councils or general queries. Town and parish councils, when they're functioning properly, have a lot to offer, and you may be of the view that there are not enough in your geographical area, and so you wish to create more. The process for doing that is a community governance review. In terms of devolving powers and transferring assets to town and parish councils, that's a separate process to reorganisation. In our experience, both community governance reviews and devolving functions and assets to parish and town councils, it takes a lot of officer time and resource. So it's important to look at where this fits into your reorganisation work plan. Both Harrogate and Scarborough councils were granted borough status as a result of the last local government reorganisation in 1974, meaning that they had mayors and deputy mayors together with a number of other ceremonial and historic privileges. Following structural change, it looked like there wouldn't be any suitable local government bodies such as town or parish councils in these areas to continue with these historic traditions. Rather than undertaking a community governance review to create new parishes ahead of reorganisation, we used the mechanism of charter trustees, which can be established as part of the structural change order to preserve historic property, privileges, rights and traditions that were enjoyed by local residents in those council areas, which would be abolished following reorganisation. Charter trustees are comprised of councillors in the wards which cover the unparished areas where the boroughs were. It doesn't create a lower tier of local authority, so unlike town and parish councils, charter trustees don't have general powers in respect of any functions or services within the area, but rather that trustee body is there to be responsible for ensuring the continuance of the historical, ceremonial and social links of the town. The Charter Trustee Regulations of 2009 set out the provisions under which the Charter Trustees may operate. They may set an annual budget to cover their running costs, and they would make a formal precept for funds from the principal authority in the same way that town and parish councils do. But in the first year, it's worth noting that the principal authority is responsible for funding the charter trustees, not residents through a precept. In order for the charter trustees to be established from vesting day, there was a reasonable amount of preparatory work required, and what we did in North Yorkshire was that we set up a charter trustee member working group consisting of those councillors who were going to become charter trustees to work through a number of practical matters to ensure that there was an orderly transition to the first annual meeting of both the Scarborough and the Harrogate charter trustees, which needs to take place within 6 weeks of vesting day. So some of the things that those working groups looked at were around identifying the historic property to be retained by the charter trustees, the nominations of mayor and deputy mayor, and their roles and the events and engagements that they would undertake. Officers were engaged to help draft standing orders and the constitution for the charter trustees together with a mayoral handbook. Practical things such as where and when the annual meeting would take place and any officer support that was required, and the cost and budget for the first year of the charter trustees.
As a monitoring officer going through this process, I would have liked to have had someone to talk me through what was going to happen prior to reorganisation, and therefore I'm going to use this slide to be a bit self-indulgent to say things that I would like to have known at the time. Firstly, it is not to underestimate the human element of change and the unknown. As you go through this process, you'll have managers, including monitoring officers, who are concerned about their own roles while still having to provide leadership to their team. In my experience, monitoring officers have it inbuilt in their DNA to do the right thing and collectively will ensure that organisations and the transition will operate lawfully. However, the sooner that teams can work together and communicate freely, the better. Also, you may have to deal with difficult issues where others have vested interests, like advising on the appointment of the head of paid service, and you continue to ensure that you work to the best interests of the council as a whole and not to individuals. It can also be a time of mistrust where people think that others know more than them, and it is rarely, if ever, true. And therefore, once a decision is made on the new structure, colleagues need to come together quickly to deal with all the work and create a sense of one team. In our experience, we found that we needed to try and retain our good staff, as there's lots of work to be done for years after reorganisation, and it's genuinely an exciting place to be. And my final point is to try and use in-house teams as much as possible, as consultants will not stay to see the effects of their advice, which staff will, and staff will be more vested in it and will be able to reflect the local circumstances better. And finally, on behalf of Jen and I, can I just say thank you for listening to this presentation, and if you have any queries regarding what you've heard, please do not hesitate to contact us. Thank you.